In August of 2017, I contacted the Texas Supreme Court. By September of 2017, I contacted the Texas Supreme Court in order to affirm. There was perhaps a discernment that needed to be made concerning the time frame. It's a time frame that was up to 60 days, but by January of 2018, I had affirmed. I maintain my affirmation. Right now in Texas, there is a manner in which we can actually address not only the border crisis but other sundry matters in a manner that is completely constitutional and that allows for the dignity of all of the people in Texas. It's actually part of Texas history. It's one of the things that I've had a great pleasure and challenge to learn since I've been here. At the founding of Texas and most of the initial leadership of Texas came from a variety of different places. And the Texas Revolution is a very important matter. What is going on now is a very significant challenge to not only the integrity of the concept of Texas as either a state or even a republic, but is a potential event that can provide many people with an inspiration of what the actual spirit of the people, if it is put toward the end of independence, can actually accomplish. There are numerous laws that have already been effected from and in the state of Texas. By the time I contacted the Texas Supreme Court in 2017, this was the law at the time. If necessary, I can and will provide a constitutional argument for A, understanding that the laws that were invoked at the time my petitions were filed are the laws that need to be considered in this manner, especially insofar as since then I have filed formal petitions to challenge the constitutionality and to specifically request articles of impeachment against the current Texas State Senate based upon engaging in a seditious and unlawful process under the auspices of performing a government function. Also, if need be, I can provide a constitutional argument for what I would understand to be a legitimate and just cause for the state of Texas to secede from the federal compact and to be in a position where it can engage in some process of referendum so that the people can determine what kind of constitutional governance it wants to take, either as an autonomous territory, an autonomous country and nation, and or some other kind of arrangement based upon a reconsideration or renegotiation of our alliance with the federal government. However, at this time, there's already precedent that has been established, and I am going to acknowledge that by the end of 2017, I had already come up with what I understood could have been a process that people of Texas could have engaged in order to address what I understood were emergent threats that not only challenged the security of the state of Texas and the people of Texas, but also could have national security implications that may well have global security implications. And so I'm going to share that with you now. I have assembled a series of legal acknowledgments of what could have been done and what could be done right now within a particular time frame. We can have most of this accomplished within the next 2 months if we were to put our minds to it and we were to work together to do so. I am going to go through and I'm just going to very basically describe various laws that are already the law of the land that could be applied in this regard. So give me just a second here. Okay, so first is Section 437.004C of the Texas Military Code regarding regulated Texas military forces. Discusses the role of the governor obtaining from the United States government arms, equipment, munitions, or other military supplies to which the state is entitled for use by the Texas military forces. Section 437.05312 concerning the duties of the Adjutant General, specifically regarding appropriation, selling, or destruction of property and supplies, or the exchange of property and supplies for other military property and supplies. Section 437.110 of the Texas Military Code concerning post exchanges, regarding a preclusion on having more than 3 potential spirits available, and under a state of readiness or a declaration of emergency in which there would be a state military or a state militia response, the prohibition on the selling of distilled spirits. I argue that distilled spirits has a specific implication, but that it also, in the state of Texas, would reference items that would then also be connected to anything associated with the Texas Alcohol and Beverage Code. Section 437.114C of the Texas Military Code concerning the execution of bonds in the name of the state is necessary in order to obtain the aforementioned property. Section 437.114A concerning subsistence, medical, signal engineering, and other supplies that can be acquired. Section 437.153B of the Texas Military Code concerning the borrowing of money, issuing and selling of bonds, authorizing the Texas Public Finance Authority to sell bonds in any manner it determines to be in the best interest of the department, and acquiring the approvals concerning the comptroller and the attorney general. Then from there would be a discussion of section 437.118B, use of funds to support military housing and training. The department shall maintain and operate changed military housing in accordance with policies and regulations adopted by the Adjutant General and published on the department's internet website. Then from there, we can begin a compilation and an inventory of housing stock and or habitations, including buildings that may have been previously zoned for commercial use and can be rezoned in order to accommodate people for the purposes of habitation, in order to then apply the necessary means by which to provide for housing and other kinds of support up to and including training. Then there is section 437.155F of the Texas Military Code concerning acquisition, management, and pledge of rents, issues, and profits, talking about a specific fund that can be managed in order to provide for rents associated with provision of military housing and or training. And then there's an understanding section 437.218A, Texas Military Code concerning tax exemption. Now, under this specific code, it discusses an officer in the Texas Military Forces exempt from payment of road or street tax. I believe that this can be addressed within the context of the other aspects of the Texas Military Code in a very expeditious manner, in order to have a temporary exemption from tax as needed and allow for that tax to actually be provided for as part of the other kinds of financing that could be engaged during this time frame. And in the course of that, allow for the good faith and credit of the people that have come together to provide a foundation for the issuance of bonds that would then provide a basis for obligations that can be assessed and can be credited insofar as people participate in the various processes necessary in order to restructure and reorganize during this time frame. From there, we would then consider the other aspects here, which are under the Texas Government Code, because ultimately what this is about assuming a temporary state of readiness in order to be able to create a peaceful and democratic situation that follows. As they have said, there's no point of going to war if you don't want to win the peace. What is the understanding of the peace that we are seeking in a situation that is as extraordinary as the one we're in? It's one of the things to first consider is section 9.003A of the Texas Government Code, Home Rule Municipality, concerning the selection of a charter commission on or after the 40th day after the date of the charter commission completes its work, i.e. establishment of zones of participation in the capacity to engage in a form of home rule municipality. This could also include an establishment and a justification for understanding various processes that were already ongoing in the state of Texas and that had previously been legal before there were unconstitutional actions that were engaged not only by the governor of Texas but also by the Texas legislature concerning the concept of a sanctuary city and what that entails, as well as the appropriate form of obligation and responsibility entailed by municipalities that would designate themselves as a sanctuary city or a municipality, including a home rule municipality, that would provide certain provisions for the people within. Section 9.002D1A concerning the Texas Government Code, talking about, again, the selection of the Charter Commission, which would be the governing body of the municipality, which means that it would be behoove the people within these particular municipalities to determine who would provide the initial commission. Understand, this is a very significant responsibility. I hate to put it into corporate language, but a city council, for instance, or a charter commission is, among other things, responsible for the fiduciary matters associated with the municipality. One of the things that Texas had to struggle with in its inception, and that was part of the early first 50 years of the Republic of Texas and then later the state of Texas, was a decision on whether or not to join in with slave states. This is a very important matter. This is exactly what we're dealing with now, regardless of how anybody else wants to couch it. Right now, we are in a situation where, under an alleged state of emergency that I contend has been mischaracterized, because ultimately what is actually going on is more about processes of understanding weapons and weaponization efforts that were not around at the time of the founding of the United States or even the founding of the Republic of Texas, and yet can be used both to offensively engage in activities as part of the already existing militia, or can also be used to defend us against incursion that could also be attempting to extort us into cooperation with illegal activity, including by those that seek to undermine our democratic or constitutional government and or try to cow us into submission to hostile forces from foreign countries. The remedy for this is to understand that we have a constitutional right in the state of Texas to alter, abolish, or reform our government as we see fit and as we need. And in the course of that, it is important that certain people step up to take responsibility. It is possible and it is constitutional, as I will also explicate in the rest of what I'm about to provide, for us to take our own matters into our own hands and to establish terms related to financing and financiability of our efforts. If somebody is attempting to extort us into a situation of illegal debt that is predicated upon accepting peonage or even worse, slavery for its accomplishment, we have not only a constitutional right and duty, but the means at hand in order to prevent them from trying to impose this upon us. And I contend that's exactly what we need to do right now. That we are in a position where we can take advantage of things that were already put on the public record, even within the United States of America, including during the 2008 banking bailout, that were supposed to be done that were not done. Where we can actually reassess, reaffirm, and recharacterize based upon our actual conscious commitment and engagement in works with each other, a situation where we understand our own value and we apply it. And when we understand our own value and we apply it, there is absolutely no justification for trying to bond us or obligate us to unconstitutional situations up to and including slavery of other people or ceding to it ourselves. So from there, we would then go into Section 20.021 of the Texas Government Code, form of government and home rule municipality. Municipality may adopt and operate under and form a government, including aldermanic or commission form. So it would be up to the charter and the charter commission to determine the specific kind of municipal government, as long as it comports within the bounds of the Constitution. Then we would be Section 9.005B of the Texas Government Code, adoption of a charter. So the governing body of the municipality enters as an order the record of the municipality. So once those means are accomplished, they go on the record, they charter the city, and then once this is in effect, then there can begin a process of a transition wherein the military situation, which also included the, if necessary, appropriation, selling, destruction, or even acquisition of property in order to provide people with their needs and to make sure that we had what we needed in order to be able to provide the foundation for the establishment of these various home rule charters can be accomplished. And then once they go on the record, the transition can then be negotiated. Now, under the code of the state of Texas, there is a 40-day period after the announcement. That's a very, very short period of time. But if the process is engaged and done correctly, it should not be a problem. Now we go to another section here, which is section 88.002 of the Texas Government Code concerning the application of surety to terminate liability on bond. A surety on the official bond of a county officer may apply to the commissioner court to be relieved from the bond. My contention is that if these different municipalities and their home rule charters engage in an appropriate process and establish that they have done what they needed to do to comport themselves within the bounds of the Constitution, that we, insofar as we would be issuing bonds in order to provide for what we need during this time frame, would have the credit that we need and the process we need to be able to refinance whatever would be identified or mischaracterized as being our obligation. There are a number of terms right now that are going on under the auspices of financing processes in the state of Texas as well as in the federal government that are completely unconstitutional. They are not our responsibility. We do not owe for these kinds of debts, and we certainly do not owe for these kinds of debts if the means by which these illegal debts are attempted for accomplishment violate constitutional preclusions against slavery or acts that legally constitute slavery, including peonage or some other form of indentured servitude or forced labor without payment or compensation. So, insofar as it is right here in the Texas Government Code, a process can be engaged for us to issue our own bonds and to provide sureties that would allow for the termination of any alleged liabilities that would be identified as being our responsibility. The means by which those terminations are accomplished and how they are characterized would be the kind of thing that prudent individuals would provide the appropriate people with whom to negotiate. Then from there, we can deal with section 88.0081 and section 88.0082 concerning self-insurance instead of bonding. Now, this is the kind of thing we are going to need individuals to discuss in terms of a possibility regarding an understanding of the difference between having a bond and the difference between behind a concept of self-insurance. I contend that for the last 5 years, consciously for the last 3 years, I've been involved in a process of attempting to address matters that would relate to what would be considered self-insurance as a personal individual, but also a concept of self-insurance insofar as a self also constitutes a understanding of a person, and personhood also has to do, legally at least, with concepts of incorporation. This kind of incorporation could also address matters related to municipalities. Now, these technical nuances are absolutely necessary for us to comport ourselves in regards to, and for us to be conscious of and cognizant of and to engage in. This was the kind of basic primary education on democratic participation we should have been provided with our whole lives. It should have been a part of our basic education. It should have been a priority not only for the state but for the country and for anybody that wanted to be an international partner with us. That we are at the point we are, and we do not have this, at least do not have this in a large enough scale for it to be a part of our everyday vocabulary, is part of what has denied us the means by which to defend ourselves against aggression. It is part of why I recited what I did earlier about the arguments that were made by the Supreme Court in consideration of our right to bear arms. Our right to bear arms is not just about a firearm. It's also about the means, including the financial means, to defend ourselves against attempts at extortion. That's what we need. And from there, we can also discuss matters related to Section 105.053 of the Texas Government Code concerning the solvency of surety company and adequacy of securities regarding investigation of the value of securities pledged by a depository to secure municipal funds, i.e., if there are anticipated or expected that we are to be obligated to existing municipal securities, then we need to assure that they are accurate, they are reflected accurately, and if there has been any foul play or any attempt to engage in fraud or deceit in trying to obligate us, then it is exposed and we seek and apply the appropriate remedy, which can also include Section 105. Section 105.054 of the Texas Government Code concerning a surrender of the interest on securities. The municipality shall surrender when due interest, coupons, or other evidence of interest on securities deposited by the depository with the governing body if the securities remaining pledged by the depository are adequate to meet the requirements of this chapter and of the governing body. So, if in the course of issuing municipal securities, there was a situation wherein interest payments on those bonds were to be provided to individuals that had engaged in bad faith or had attempted to engage in unconstitutional processes concurrent to the relationship to the issuance of those municipal securities, that the interest can be surrendered to the individuals that are a part of the governing body so that it can then be applied to the best interest of the people as opposed to being allowed to be extracted or expropriated from the people in order to be able to award to or reward individuals who may engage in activities up to and including abusing their role in the issuance of those securities in efforts to try to extort people into cooperation with unconstitutional activities. If these individuals that are involved with these interest payments are state actors and or hold any contracts with the state insofar as they may believe that they're entitled to provide services to the state, then that would need to be addressed accordingly and could be addressed through this process. Then we go on to Section 105.073 of the Texas Government Code concerning deposit of funds not later than 60 days from the date the governing body of the municipality designates a depository. So in the course of these activities, after these matters have been established, the particular municipalities of concern will have 60 days to determine what the depository institution of concern will be following transition, which is something that would be engaged as part of the process associated with the transition. State of readiness and participation in an effort of this sort is going to allow for people to display and present their skills and capabilities in a manner that might not otherwise have been capable or possible. During the course of that, the concept of and the configuration of what would be considered an appropriate depository and the kind of depository that would take form would be very much a part of the kinds of activities and conversations and actions engaged by the people that were involved in the process of transitioning. So in the process of transitioning, people are going to be engaging in a consideration of what it means to grapple with their understanding of not only the financial reality, including in manners that they may not have been previously apprised of, as well as what it meant to participate in the matters leading up to the foundation being provided for that transition, as well as the transition itself. The hope here is that people take ownership of what we're doing. We take ownership of what we're doing. And in taking ownership, we understand we have a vested interest in making sure it's done correctly. And not only is it done correctly, but it's done in a way that can be held accountable for the long term. And we understand our interest in holding it accountable. And finally, just a few more points, and then we should be ready to go, which has to do with Section 107.006 and Section 107.008 of the Texas Government Code concerning obligation as refinancing, including under the pension fund, and then a concept of an understanding of a process whereby credit agreements can be renegotiated, and issues concerning what it is that constitutes credit and who has it are dealt with and addressed appropriately. Now, I understand that one of the things that allegedly was supposed to be on the agenda for the Texas legislature this session had to do with unfunded pension liability and pension obligation. We are in a situation where right now, who has what obligation is being significantly challenged. We can meet it. We can meet it very quickly. We can meet it within the next 6 months. And if we don't, we have no excuse.